Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a motion for sanctions filed by Blake Lively against most of the Wayfarer parties and their counsel. I know a lot of people are probably going to think this has to do with the whole Taylor Swift claim situation and the documents that got struck. It looks like it doesn't. So we're going to go through this together, but from the skimming it, I saw that they were saying, a lot of the claims were frivolous and meant to harass Blake Lively, so we'll see how that goes. I know lots of people are not going to like that. I mean, I'm not either, but, give me just 1 minute to pull this up. Sorry for the delay, but you guys know I'm also working during the day, so I had to finish something up. Okay. I see we have Anna Fan, the tax attorney, here with us. I haven't seen Anna in a minute. Anyway, she says that these things are almost never granted, and it's mainly like probably a PR thing. Which I gotta say, I think there's a lot of PR stuff going on both sides here, but I'm pretty much fine with it when it comes from the side that I like, and I'm not when it comes from the side that I don't like. But at least I'm honest about that. So, all right. Hopefully, you guys can see that okay. Defendant Blake Lively brings this motion for sanctions pursuant to Federal Rule of Civil Procedure 11, requesting the court to impose monetary sanctions against plaintiffs Steve Sarowitz, Jamie Heath, Melissa Nathan, Jennifer Abel, It Ends With Us movie, let's see, their attorneys Brian Friedman and Mitchell Schuster, and their attorneys' respective law firms. Okay. So Justin Baldoni isn't listed as an individual there, but most of the Wayfarer parties are listed there. So give me 1 second. So this is this is like a different situation here. I know, didn't the judge have to give Friedman a warning before sanctions? We're gonna take a look at this and figure out what's going on with that, because I'm a little confused as well, but we'll see if we can figure that out together. All right. The Rule 11 plaintiffs and counsel have asserted in the amended complaint claims against Ms. Lively that have no reasonable basis in law or fact and clearly were brought for an improper purpose. Rule 11 exists to discourage precisely these types of claims because federal courts are venues for the adjudication of justice, not playgrounds. God damn it. All right. Not playgrounds for retribution or public relations. I knew this was going to frustrate me in the first paragraph, didn't I? Every lawyer certifies under Rule 11 that the pleadings they file with the court are not frivolous, legally unreasonable, or factually without foundation, and are not being presented for any improper purposes, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Whoa, hold on. Didn't this chick just file 1,000 pages with the Texas court to bury some guy who doesn't have the financial means to defend himself? Jesus fucking Christ. All right. Failing to meet these standards subjects both lawyers and their clients to sanctions. The Rule 11 plaintiffs and their counsel have violated Rule 11 in every respect. As to an improper purpose, that the FAC was filed principally as a vehicle to seed harassing media narratives against Ms. Lively is obvious. The examples are legion, from its legally meaningless 178-page Exhibit A to counsel's ghoulish taunt that Ms. Lively should testify about her degrading experience of sexual harassment at Madison Square Garden before 20,000 spectators and streamed to the world. Hey, wait, when did we say we were letting 20,000 people in? Just curious. To using the court's docket to level baseless allegations of extortion and spoliation of evidence against Ms. Lively and her counsel. So I guess they did mention that there, yes. Let's talk about the timeline Exhibit A, 178-page Exhibit A. So I have heard that that is not like a normal thing to do. You can't just attach like this huge evidence timeline to a complaint like that. I don't know the ins and outs of that and why that's not proper, but I have heard a lot of attorneys say that. So that, I don't know that it warrants sanctions. Maybe ask Anna in the chat if she knows. But I have heard that that's not normal. As far as the testifying about her degrading experience of sexual harassment, well, there was no degrading experience of sexual harassment, so I don't really find the joke that offensive. But that's just me. As to the FAC's legal and factual basis, there is none. Well, that's to be seen, isn't there? Like, what? Oh, I guess we'll just pack it in then. If you say so, that's fine. The Rule 11 plaintiffs assert claims for breach and interference with contracts to which they are not a party, and for extortion related to a film in which they have no contractual or other right. Huh? In its whopping 224 pages, not you complaining about a page count again, the FAC contains nothing connecting any of the Rule 11 plaintiffs to these claims against Ms. Lively. Specifically, one, Mr. Sarowitz, Ms. Nathan, Ms. Abel, and it ends with us LLC, each sued Ms. Lively for extortion, but the FAC contains no facts that Ms. Lively made any extortionate threats against any of them, or deprived them of anything at all as a result. I can kind of see where this is going, and I feel like both sides could make this same type of argument, and honestly, it's very annoying. But okay. Mr. Heath, Mr. Sarowitz, Ms. Nathan, Ms. Abel, and it ends with us LLC each sued Ms. Lively for interference with a contract and prospective economic advantage related to talent agency WME, with which they had no contractual or economic relationship at all, much less one that Ms. Lively unlawfully interfered with. And 3, they each sued Ms. Lively for breach of the covenant of good faith and fair dealing, but the FAC contains no facts that any of them were parties to the actor agreement that claim is based on. Okay. The Rule 11 plaintiffs and counsel have had ample notice that their conduct was sanctionable. Ms. Lively has repeatedly explained the glaring and fundamental defects in these claims, both in her motion to dismiss and 21 days ago in safe harbor letters addressed individually to each of the Rule 11 plaintiffs and counsel. They could have sought leave to amend their claims after receiving multiple motions to dismiss in the safe harbor letters, but expressly declined to do so, even though the court reminded them on April 11th that they were on notice of the asserted flaws in the FAC and invited them to seek leave to amend. Instead, the plaintiffs expressly declined the court's invitation and have opted to wait to see how the court rules and then try to amend their pleadings for good cause, a tactic that courts in this circuit heavily disfavor. Okay, so in the footnote here, let's see. Well, we missed footnote 2. It says this was actually the second time the court addressed the pleadings, noting at the February 3rd trial setting conference that Exhibit A did not appear to be proper and was likely subject to being stricken. The federal rules do not afford the Rule 11 plaintiffs and counsel the luxury of waiting and seeing what happens with patently baseless claims. It is their responsibility in the first instance not to file them, or when they are shown in clear terms why their claims are fatally flawed, to dismiss them or move to amend, not shift the burden to the court to sort it out for them. Given the foregoing, Rule 11 sanctions are more than warranted here. The first and most appropriate sanction is an award of attorney's fees incurred by Ms. Lively in connection with her defense of the frivolous claims, as well as in the preparation of the instant motion. Pursuant to Rule 11C1, this sanction is appropriately imposed against Mr. Friedman, Mr. Schuster, their respective firms, and the Rule 11 plaintiffs. In light of the egregious circumstances presented here, and the court's recent admonishment to plaintiffs' counsel that their conduct in this forum may be sanctionable, the court may also wish to consider whether additional sanctions are appropriate as to plaintiffs' counsel. On January 31st, barely 2 weeks after filing an initial complaint and 11 weeks before the deadline to file a motion to amend, plaintiff Justin Baldoni and the rest of the Wayfarer parties filed a First Amendment complaint asserting 9 causes of action against Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, and the New York Times Company. They also attached a timeline telling the Wayfarer party's version of events through a lengthy narrative, a document that this court expressed doubts as being an appropriate pleading. Brian Friedman and Mitchell Schuster both signed the FAC on behalf of their respective firms. The FAC asserted 7 causes of action against Ms. Lively, every Wayfarer party asserted a claim for 1, civil extortion, 2, intentional interference with contractual relations, 3, intentional interference with prospective economic advantage, 4, negligent interference with prospective economic advantage, 5, breach of the implied covenant of good faith and fair dealing, and 6, defamation. Mr. Baldoni, Mr. Heath, Ms. Nathan, Ms. Abel, and Mr. Sarowitz also brought a claim for false light invasion of privacy. With one exception, the false light claim, each cause of action was asserted by all of the Wayfarer parties against Ms. Lively, including the Rule 11 plaintiffs. On March 20th, Ms. Lively filed a motion to dismiss the First Amendment complaints as to the 7 claims brought against her. Okay. On April 3rd, the Wayfarer parties jointly filed their opposition. On April 23rd, pursuant to Rule 11C, Ms. Lively served each of the Rule 11 plaintiffs and plaintiffs' counsel with letters, safe harbor letters, demanding that, among other things, 1, Mr. Sarowitz, Ms. Nathan, Ms. Abel, and It Ends With Us LLC withdraw their civil extortion claims. 2, all Rule 11 plaintiffs withdraw their interference claims. And 3, Mr. Sarowitz, Ms. Nathan, Ms. Abel, and Mr. Heath withdraw their implied covenant claim. The safe harbor letters indicated that if the Rule 11 plaintiffs, through their counsel, failed to withdraw these claims within the 21-day safe harbor period prescribed by Rule 11, Ms. Lively would seek sanctions from the court. The Rule 11 parties have refused to take any action to address the many flaws and deficiencies identified in the safe harbor letters. Instead, in a May 13th response, they advised that they were standing by every word of their faulty and frivolous pleadings. Well, I'm sure they didn't word it like that, but all right. And it is kind of rich to read something like this and remember exactly what's going on the other side of this, where they, obtained all those messages off of Jen Abel's phone, got that evidence improperly, filed a lawsuit using all John Does and a shell company, and then proceeded to give that to the New York Times and bring a claim based on all that. So it's kind of hard for me to take any of this, too seriously, I guess. But, I've never tried to hide my bias. So, one sec. Millennial Mom, thank you for the 5. Yay, Lauren, thank you for being so on top of this. We adore you. Well, thank you very much. I appreciate that. So, when we get into the legal standard stuff, you're going to see me start to skim through a lot of this because we still have those letters to go over. Okay. Rule 11 requires an attorney to certify that 1, a pleading or motion is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. And 3, the factual contentions have evidentiary support or, if so specifically identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So what's the problem here? An attorney may not transcend the facts of a given case, and counsel may not concoct facts that are not well grounded. Okay. An attorney who files a paper that no competent attorney could believe after reasonable inquiry is well grounded in fact violates Rule 11. What, like a John Doe shell company fake lawsuit? What? The standard for triggering sanctions under Rule 11 is objective reasonableness and is not based on the subjective beliefs of the person making the statement. Thus, an attorney files a pleading or motion in violation of Rule 11 if it is frivolous, legally unreasonable, or factually without foundation, even though not signed in subjective bad faith. The rule is implicated where an attorney or party declines to withdraw a claim upon an express request by his or her adversary after learning that the claim was groundless. Okay. The civil extortion claims brought by Mr. Sarowitz, Ms. Nathan, Ms. Abel, and It Ends With Us LLC against Miss Lively are legally unreasonable and factually baseless. Okay. Have no factual or legal basis, and the Wayfarer parties have not even attempted to assert one. The extortion claims are not supported by a single allegation that Miss Lively took any action with respect to Mr. Sarowitz, Miss Nathan, Miss Abel, or It Ends With Us LLC, much less that she threatened or demanded anything from them. When these defects were raised in the Lively motion to dismiss, the Rule 11 plaintiffs had no response and, incredibly, have since suggested that they would uncover facts regarding the fictional extortion against these parties in discovery. It is difficult to conceive of a more blatant example of utter frivolity okay, than the notion that one would have to conduct discovery to even articulate how one was extorted by the person one is suing. That should have been the first clue that asserting the claim was sanctionable. If the threat cannot be stated, it did not happen. I'm not really seeing it that way. But okay. The extortion claims and the related requests for punitive and exemplary damages assert that Miss Lively made threats to the Wayfarer parties that included demands that money, property, services, or other sources of value be conferred upon Miss Lively without consideration or contractual entitlement thereto. In support of these claims, the FAC identifies just 2 incidents, neither of which involve any threats or demands directed towards Mr. Sarowitz, Miss Nathan, Miss Abel, and It Ends With Us LLC at all. For example, in their opposition, the Wayfarer parties claim that Miss Lively supposedly demanded that the Wayfarer parties issue a humiliating and false statement, taking blame for Miss Lively's press woes. But as their own complaint demonstrates, this purported demand has nothing to do with any of Mr. Sarowitz, Miss Nathan, Miss Abel, or It Ends With Us LLC. The thing that I love about this is it's not, no, that didn't happen. It's, yeah, I was an asshole, but not to these people specifically. All right. We've already seen that, by the way, so I'm going to skim over that. The same is true with respect to the second purported extortionate act identified by the Wayfarer parties, that Miss Lively purportedly demanded that Mr. Baldoni, Mr. Heath, and Wayfarer submit letters to the PGA in support of her certification for the PGA mark, which Mr. Baldoni and Mr. Heath ultimately did, while also creating a paper trail that said, I don't actually want to do this, I just kind of have to. But I guess we're going to leave that out. Simply put, the only threats or demands the FAC wrongly alleges that Miss Lively made were to Mr. Baldoni, Mr. Heath, and Wayfarer, and none of the others. To be clear, Miss Lively's purported demands that Mr. Baldoni, Mr. Heath, and Wayfarer issue an apology or submit letters in support of her PGA mark are themselves not extortion. Well, okay. We're framing them as just demands. We're not, okay, we're leaving out quite a bit here. And would still subject the claim to dismissal pursuant to the Lively motion to dismiss, no matter who brought them. But these allegations have nothing to do with Mr. Sarowitz, Miss Nathan, Miss Abel, or It Ends With Us LLC, who sued her for extortion anyways. Confirming this, neither the Wayfarer party's exhaustive 168-page Exhibit A timeline, nor their opposition to the Lively motion to dismiss, assert any factual basis that any of them reasonably possess, nor could ever reasonably possess, a civil extortion claim against Miss Lively. No competent attorney could believe, after reasonable inquiry, that these allegations support the extortion claims brought by Mr. Sarowitz, Miss Nathan, Miss Abel, or It Ends With Us LLC. Miss Abel and Miss Nathan are public relations professionals who are not alleged to be, and are simply not, the owners, executives, or employees of Wayfarer, and had no role in connection with the production of It Ends With Us. As to Mr. Sarowitz, the FAC includes no allegations regarding his relationship to Mr. Baldoni, Mr. Heath, or Wayfarer, but even if it did, no such relationship alone could provide a basis for the extortion claim. There's a footnote here. It says the only allegation regarding Mr. Sarowitz included in the FAC referenced in his extortion claim is that Mr. Sarowitz is an individual residing in the county of Lake, Illinois. Hey, Donna, what's up? It's a little hard to sum up so far, but I mean, I guess they're just saying these claims are frivolous. The ones that are brought by the most of the Wayfarer parties are frivolous and meant to harass, etc. So, the same is true for It Ends With Us LLC. The FAC includes no allegations suggesting a relationship between It Ends With Us LLC and Mr. Baldoni, Mr. Heath, or Wayfarer. And even if the FAC did so, it doesn't. That would not justify a civil extortion claim brought by It Ends With Us LLC itself against Miss Lively. I don't know about this. No allegations suggesting a relationship between the movie LLC and Baldoni, Heath, and Wayfarer. I don't know about that. I don't think that's true. But I'll have to go back and look at it. Not now, please. By collectively suing Miss Lively for civil extortion without alleging facts supporting extortion as to each of them, Mr. Sarwitz, Miss Nathan, Miss Abel, and It Ends With Us LLC have brought frivolous, baseless claims against her because plaintiff's counsel also refused to move to amend or otherwise dismiss those claims when the defects were brought to their attention. They violated Rule 11, and sanctions should be imposed on them and the Rule 11 plaintiffs. Okay. The interference claims brought by Mr. Sarwitz, Miss Nathan, Miss Abel, Mr. Heath, and It Ends With Us LLC against Miss Lively are legally unreasonable and factually baseless. None of the Rule 11 plaintiffs can reasonably assert a claim for interference with a contract or relationship that they never even had. This is where I'm kind of like, are you serious? Because you tried to sue these people for a contract with a company that was like inactive and you didn't even list them by name. And I understand these are two unrelated things, but it's still just kind of hysterical to read this and be like, you know what you did, right? You remember what you did? Because this is just not going to fly. Oh, man. One sec. She needs to keep the Spice Girls out of this. What did I miss this weekend, man? All right. Indeed, the FAC pleads no facts and lacks any legal ground to suggest Miss Lively interfered with any of the Rule 11 plaintiffs' contracts or business relationships. Instead, the Rule 11 plaintiffs bring 3 interference claims against Miss Lively based exclusively on purported relationships between other parties, Wayfarer and WME, and between Mr. Baldoni and WME. Okay. This was made abundantly clear in the Wayfarer party's opposition to the Lively motion to dismiss, which clarifies that while the FAC imprecisely pleads that the Wayfarer parties had a contract and business relationship with WME, the purported interfering acts were intended to induce WME to cease working with Wayfarer or Baldoni. The allegations that Miss Lively interfered with Wayfarer's and Mr. Baldoni's WME relationship does not provide a reasonable basis for the Rule 11 plaintiffs to assert tortious interference claims of their own. Of course, the existence of a relationship is a core element of a claim that such relationship has been unlawfully interfered with. Okay. But there are no facts to support any contention that any of the Rule 11 plaintiffs were parties to a contractual or economic relationship with WME, nor any facts to suggest Miss Lively interfered with any such relationships between the Rule 11 plaintiffs and any other third parties. As for Mr. Sarwitz, Mr. Heath, and It Ends With Us LLC specifically, even if they added facts to plead more specific roles that more clearly connected them to Wayfarer's relationship as an alleged client of WME, such as executives, financiers, or affiliates, which they did not do, they still would not give them, that still would not give them any legal or factual basis to sue Miss Lively in the interference claims. Without any facts or law to support their most fundamental elements as to any of the Rule 11 plaintiffs, the interference claims are utterly frivolous as to all of them. Because they collectively sued Miss Lively for the interference claims without any factual basis and also refused to move to amend or otherwise dismiss those claims when the defects were brought to their attention. Plaintiffs' counsel violated Rule 11 plaintiffs, and along with the Rule 11 plaintiffs should be sanctioned. Plaintiffs' counsel violated Rule 11 plaintiffs. What? Did I read that right? Shouldn't I just say violated Rule 11? What are we alleging here? I'm confused. All right, moving on. The implied covenant claims brought by Mr. Sarowitz, Ms. Nathan, Ms. Abel, and Mr. Heath against Ms. Lively are legally unreasonable and factually baseless. Like the interference claims, the implied covenant claims advanced by Mr. Sarowitz, Ms. Nathan, Ms. Abel, and Mr. Heath is equally frivolous. According to their complaints in the opposition to the motion to dismiss, the implied covenant claim arises from an actor agreement between Ms. Lively and Wayfarer, pursuant to which Ms. Lively would take the lead role as Lily Bloom. And like the interference claims, there is no conceivable contractual relationship between any of Mr. Sarowitz, Ms. Nathan, Ms. Abel, or Mr. Heath on the one hand, and Ms. Lively on the other. Accordingly, given the basic elements necessary to establish the implied covenant claim have never existed, for each of them to nevertheless assert the same is frivolous, triggering the consequences of Rule 11. The Rule 11 plaintiffs' baseless claims were brought for the improper purpose of harassing Ms. Lively, causing delay and increasing the cost of litigation. From the inception of this matter, plaintiffs' counsel have repeatedly carried aggressive and offensive flood the zone tactics, what PR tactics? Designed to confuse and mislead the public regarding the nature of this litigation. Ma'am, are you going to pretend you're not doing the same shit? Come on. Just last week, plaintiffs' counsel, specifically Mr. Friedman, filed 2 letters and an affidavit so inflammatory and improper that they were stricken from the record. I mean, remains to be seen if they were 100% true or not. Let's keep that in mind. But, you know, not a popular opinion, but I can kind of see why they were taken off, you know? I kind of get it. This was not the proper venue for that. But this is not the first time that Mr. Friedman has publicly attacked Miss Lively and her counsel. On the contrary, he has repeatedly used the press to target Miss Lively, including by asserting Lively's recent motion to dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. Well, that's just true. That's just true. I mean, okay. Stringent rules are put into place to protect the innocent and allow individuals to rightfully defend themselves. Laws are not meant to be twisted and curated by privileged elites to fit their own personal agenda. I mean, he's not saying anything I haven't said 1,000 times, but in more colorful language. As we said yesterday in response to Mr. Reynolds' same cowardly measures, we will continue to hold Miss Lively accountable for her actions of pure malice, which include falsely accusing my client of harassment or retaliation. Miss Lively's fantastical claims will be swiftly debunked as discovery moves forward, easily disproved with actual evidentiary proof. Okay. So I'm reading that and I'm thinking, have you not said a stuff that's a gazillion times worse? You're over here, you know, championing yourself as some sort of now women and girls' rights activist and protector, outright saying, you know, Justin Baldoni is trying to silence you as a victim of some kind of inappropriate sexual conduct. I mean, whether or not there's a legal problem with this paragraph, personally, I couldn't give a fuck because it's the truth. So again, maybe it is just targeting in the press, but in my opinion, that needed to be said. So again, I can't tell you how a judge is going to rule on this or how the judge is going to see it. I can only tell you how I see it. All right. So I guess they're quoting him some more here. It is shameful that Ms. Lively and her representatives would make such serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives as yet another desperate attempt to fix her negative reputation, which was garnered from her own remarks and actions during the campaign for the film. Okay, again. I mean, her attorneys are making the same kind of statements. So what's your fucking problem? All right, one sec. is painfully ironic that Blake Lively is accusing Justin Baldoni of weaponizing the media when her own team orchestrated this vicious attack by sending the New York Times grossly edited documents prior to even filing the complaint. And that right now, again, is just true. And so I think that's why I have a hard time even seeing this from the lens of someone sympathetic to Blake Lively. Is, she went and did that all sketchy stuff to get that to the New York Times. The New York Times then gave them like 3 seconds to respond on the weekend before Christmas, and then put all that out there the next morning, earlier than they said they would. So if this is a PR tactic, filing these things back and forth, they're not coming out on the winning side of this. We are releasing all of the evidence which will show a pattern of bullying and threats to take over the movie. None of this will come as a surprise because, consistent with her past behavior, Blake Lively used other people to communicate those threats and bully her way to get whatever she wanted. We have all the receipts and more. The irony is not lost on anyone that Miss Lively is so petrified of the truth that she has moved to gag it. And I guess that was when she was trying to get a gag order before that February 3rd conference. The immense power that she wielded in Hollywood, built on pure fear for her husband and their powerful friends, came to an end the moment Miss Lively planned a mass distribution of a disturbingly false and well-calculated hit piece in the New York Times. Miss Lively did this with the sole intent to ruin the lives of innocent individuals, and then went the extra mile to place blame on a fictitious smear campaign, all because she quite simply could not accept that the public had organically seen through her facade. When you accuse innocent individuals of something so disturbing as sexual harassment without thinking of the destruction it would cause to not only them, but the entire domestic violence community, this is where accountability for such mean-spirited actions must be taken. Blake isn't just hurting Baldoni by accusing him of sexual harassment when he never did anything wrong. She's also devastating the entirety of the domestic violence community by lodging the allegations. I mean, she and Ezra Hudson are out here complaining about how, they stand for the entire domestic violence community when they're trying to fight Justin Baldoni, the mean sexual harasser who, walked into her trailer when she insisted he did while she was breastfeeding or whatever the fuck. So Mr. Friedman's media statements have continued to take a decidedly darker turn. On May 8th, Mr. Friedman suggested that he would take Miss Lively's deposition at Madison Square Garden, charge tickets for admission to attend, and live stream the testimony for the world to watch. I mean, he did say he would donate the proceeds. Look, that's annoying. I could see from the other side, I could see that being annoying, but let's not pretend this was like some horrible dark thing that he said. It's obnoxious, sure, if you're on the other side, like I said, but that's not, you want to pretend this was some huge, horrible, devastating thing to say. No, it was just annoying. All right. Personally, I don't have a problem with it because, like I said, I don't try to hide my bias, so. And as set forth above, just last week, Mr. Friedman filed with the court 2 letters and an affidavit, including an accusation that Miss Lively has engaged in unlawful conduct as tools to create a press uproar, so inflammatory that they were struck from the record. From the outset of this litigation, Miss Lively has expressed concerns regarding statements made by Mr. Friedman and his firm relating to the present litigation, including a website that Mr. Friedman planned to launch to release full unedited WhatsApp, text, and email exchanges between Lively and Baldoni. Okay, so that website contains nothing but court documents, public court documents, right now. And also, I find it rich that they keep saying, like, well, he said he was gonna, show all this evidence on a website. Where is it? Where's the evidence? But at the same time, they're like, we want a gag order. Despite the court's express ruling that counsel complied with Rule 3.6 of the New York Rules of Professional Conduct, Mr. Friedman's misconduct continues as evidenced by his recent behavior. These public attacks, combined with the Rule 11 plaintiffs filing numerous claims against Miss Lively without any basis in law or fact, is willfully improper and warrants sanctions under Rule 11b1. Okay. A court may infer an improper purpose if, in light of plaintiff's conduct during and outside of litigation, a complaint is so baseless as to suggest there is an ulterior motive behind the lawsuit. Schnitzel Ninja, what are you cackling about? All right. The court should impose sanctions on plaintiff's counsel, Mr. Sarowitz, Ms. Nathan, Ms. Abel, Mr. Heath, and it ends with us, LLC. Whereas here, an attorney signs their names to an action that was destined to fail based on the facts and existing precedent, and where no reasonable argument can be advanced to change or extend the present law, sanctions are appropriate. The purpose of the imposition of sanctions is deterrence. Therefore, the sanctions must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. For the reasons discussed herein, the Rule 11 plaintiffs and plaintiffs' counsel should be jointly and, is it severely liable for an award of reasonable attorney's fees and costs to be paid to Ms. Lively in connection with this motion of related work. Further, the court should consider additional sanctions, including a penalty to be paid to the court and or a reprimand of plaintiffs' counsel for the burden they have placed on the court as a result of their filing frivolous and harassing litigation. Attorney's fees are appropriate sanctions in this case because plaintiffs' counsel and the Rule 11 plaintiffs filed frivolous extortion, tortious interference, and implied covenant claims with an improper purpose, and did not withdraw them despite the safe harbor letters demonstrating their baselessness. And who is blowing up my phone right now? One sec. Okay. Although the purpose of sanctions is deterrence and not reimbursement, sanctions may include an order directing payment to the movement of part of all of the reasonable attorney's fees and other expenses directly resulting from the violation. I'm just going to roll past that. The court should order Mr. Friedman, Mr. Schuster, and the law firms liable to pay Ms. Lively for all imposed sanctions. Under Rule 11C, once a court determines that a party or counsel violated Rule 11B, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. Okay. The Rule 11 plaintiffs should be held jointly and severally liable with plaintiff's counsel for all imposed sanctions. Because plaintiff's counsel has violated Rules 11B1 and B3 by filing factually baseless claims for a harassing and improper purpose, the Rule 11 plaintiffs should also be sanctioned pursuant to Rule 11C1. Dude. All right, one of you assholes just started texting me, one word at a time. It's me, blowing up your phone. Thank you for that. Okay. I hate you. There is no question that once a fuck. I bet you're proud of that. There is no question that once a court finds that Rule 11B has been violated by an attorney or unrepresented party, sanctions may be awarded against any attorney, law firm, or party that violated the rule or is responsible for the violation. Rule 11C5 presents the only limitation on a court's ability to impose sanctions on represented parties. A court is prohibited from imposing monetary sanctions on a represented party for making frivolous legal arguments in violation of Rule 11B2. Sanctions imposed on plaintiff's counsel and the Rule 11 plaintiffs should be substantial to sufficiently deter similar abhorrent conduct in the future. Okay. Mr. Friedman advertises himself as a litigator with over 20 years' experience and as one of the most powerful and most feared people in the media industry. Mr. Schuster is a seasoned litigator with 30 years of experience and serves as his firm's chair of the litigation department. Okay, my phone is going face down right now. Each of their firms is well-resourced and regularly practices in litigation. Nevertheless, in this action, Mr. Friedman and Mr. Schuster signed their names to an amended complaint containing numerous frivolous claims against Ms. Lively, all while targeting her in the media. As discussed above, Mr. Friedman's pattern of behavior of filing baseless claims in courts to bolster his accompanying media campaign leads to only one plausible conclusion. Plaintiff's counsel acted willfully with the intent of harassing Ms. Lively, causing unnecessary delay and increasing the cost of litigation. Okay. Plaintiff's counsel's inclusion of the Rule 11 plaintiff's frivolous claims has also infected large portions of their pleadings by intermingling the Rule 11 plaintiff's baseless claims with other Wayfarer parties in an attempt to disguise them. Moreover, despite ample warning of the deficiencies of the extortion, interference, and implied covenant claims, as well as improper group pleading, and Lively's motion to dismiss and safe harbor letters, plaintiff's counsel has had the opportunity, but refused to withdraw these causes of action. Beyond intentionally injuring Ms. Lively's reputation and career, please shut the fuck up. I can't. Plaintiff's counsels and the Rule 11 plaintiffs have, by including such frivolous claims, required Ms. Lively to exhaust significant and unnecessary resources to analyze and challenge these additional claims. They have thereby further compounded the cost and burden of defending this action, including by forcing Ms. Lively to incur the expense to prepare her motion to dismiss, the safe harbor letters, and the instant motion. Under these circumstances, the imposition of meaningful monetary sanctions may be the only way to deter plaintiff's counsel and the Rule 11 plaintiffs from continuing to unlawfully harass Ms. Lively with baseless accusations and statements to the press. What is this? The footnote here says plaintiff's counsel plainly understands that claims may only be asserted on behalf of those who have good reason to do so. In contrast to all of the other claims in the FAC, plaintiff's counsel brought false light claims on behalf of only the individual defendants, not the entity defendants. I don't know. I kind of see where they have a point there. I hate to say it, but, you know, maybe we can get the Ask Two lawyers back on this, huh? So they can tell me where I'm wrong. I should text them. Not text. I should message them. Okay. As an illustration of the Rule 11 parties' financial resources, here we go again. Okay. Mr. Sarowitz has pledged his intention to spend $100 million to ruin the lives of Miss Lively and her family. Again, that's just like a thing that you said one time and have latched onto it and put it in every single letter you've ever written to this court. Like, I don't see any proof of that. It's never put in writing. Nothing that this man has ever said has been put in writing, apparently, because if it was, they would have shown it by now. Given those intentions, which there is every reason to believe has evolved into a bottomless bank account, fuck off. A bottomless bank account funding the Rule 11 plaintiff's instant litigation, the imposition of material monetary sanctions becomes critical. For these reasons, Ms. Lively seeks sanctions in the amount of attorney's fees and costs incurred in defending against the Rule 11 plaintiff's baseless claims, including the preparation of the safe harbor letters and the instant motion, to be imposed jointly and severally among plaintiff's counsel and the Rule 11 plaintiffs. The court should impose additional sanctions, including a penalty or reprimand on plaintiff's counsel. Finally, in addition to monetary sanctions, the court should issue plaintiff's counsel a formal reprimand for the filing of baseless claims as a means of harassing Ms. Lively and gaining favor in the court of public opinion. Okay. Sorry, this lady's exhausting. The court has available a variety of possible sanctions to impose for violations, such as striking the offending paper. Well, we've already been down that road. Issuing an admonition, reprimand, or censure. That was not my door, that was my freezer. Requiring participation in seminars or other educational programs, ordering a fine payable to the court, or referring the matter to disciplinary authorities. Specifically, an attorney may be required to pay a fine, or, in the words of Rule 11, a penalty to advance the entrance of deterrence and not as a punishment or compensation. Let's see. Courts impose penalties on attorneys to be paid directly to the court because of the burden that litigating sanctionable claims places on the court and its personnel to deter such frivolous and harassing litigation in the future. Here, in addition to the attorney's fees discussed above, The court should consider whether such additional sanctions are appropriate. Okay. And then here they put the safe harbor letters. Hang on. Let me check something real quick, too. Okay. What is this? Well, that's the unseal. Hang on. I don't think this is anything new. I'll deal with that later, because other stuff right now. Okay. Give me 1 sec. Hey, I agree with what you're saying, but please stop shouting. Please stop shouting. Okay. If we could avoid the all caps in the chat, please, I would appreciate that. It's very distracting, and I already have scatterbrain, so. All right. This is a declaration from Ezra Hudson, and it's got the letters attached to it. I, Ezra Hudson, pursuant to 28 U.S.C. Section 1746, declare I'm an attorney licensed to practice law in California, blah, 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 blah. Okay. I submit this declaration in support of Ms. Lively's motion for Rule 11 sanctions. Exhibit A is a true and correct copy. Whoa. Slow down. Of the safe harbor letter and motion I served to Mr. Friedman, Mr. Schuster, and the respective law firms. Exhibit B is a copy of the safe harbor letter and motion I served to Mr. Friedman. What? Oh, by Melissa Nathan. Okay, these are just by different parties here. We don't need to read through all that. That's annoying. Attaches Exhibit F is a true and correct copy of the letter response that Michael Gottlieb and I received from Ellen Garofalo. Who is that? Huh. I'll find out. Okay. Dear Mr. Friedman and Mr. Schuster, on behalf of our client Blake Lively, we write to address the frivolous claims asserted by plaintiff Jennifer Abel against Ms. Lively, which violate Rule 11 of the FRCP. In accordance with Rule 11, enclosed, please find a copy of Ms. Lively's proposed motion, which we intend to file as to you, your law firms, and Abel, if Abel does not withdraw the following claims. 1, civil extortion. 2, intentional interference with contractual relations. 3, intentional interference with prospective economic advantage. 4, negligent interference with prospective economic advantage. 5, breach of the implied covenant of good faith. 6, defamation. And 7, false light invasion of privacy. Well, why would she remove the defamation claim? I feel like that's a pretty big one. That should be there. But okay. As you know, Rule 11 imposes a duty upon counsel to ensure any pleading or motion presented to the court is not frivolous, legally unreasonable, or factually without foundation, and is not being presented for any improper purposes, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Okay. A violation of this duty may subject both the party and the filing attorney to sanctions. For the reasons discussed herein, Abel's extortion, interference, implied covenant, defamation, and false light claims are so destined to fail based on the facts and existing precedent that no reasonable attorney could believe they were well grounded. Indeed, as described herein, Abel's claims are so baseless that the only plausible conclusion to be drawn is that you brought them for the improper purpose of harassing Miss Lively, causing unnecessary delay, and needlessly increasing the cost of litigation, all of which is prohibited by Rule 11b1. If you do not withdraw the aforementioned claims, within Rule 11C1A, oh my God, so many letters, 21-day safe harbor period, we will seek sanctions against you, your law firms, and your clients. Any such sanctions would be in addition to and independent of any costs, attorney's fees, or damages that Ms. Lively is otherwise entitled to under applicable law. Okay. So we pretty much read this stuff already. And I'm guessing these letters are all going to be kind of similar. Yeah. So this is pretty much, we'll get to the bottom where the rest of it is. Give me 1 second. So you don't have to listen to me scrolling. Better idea. Why don't I go to the top and see? There we go. I want to go down to F then. There we go. Okay, so this is from Counsel for Wayfarer. Who signed this? Let's see. Okay, yeah, got it. This firm represents, among others, and then they have the Wayfarer parties there. The following is the Wayfarer plaintiff's consolidated response to the 12 Rule 11 letters directed to each of the Wayfarer plaintiffs by your clients, Blake Lively and Ryan Reynolds. The letters address alleged pleading defects that the Lively defendants have already placed before this court in their respective motions to dismiss the First Amended complaint. The gist of the letters is that the FAC's extortion, defamation, and intentional and negligent interference claims are stated on behalf of the Wayfarer parties as a group and do not state facts sufficient to state a claim on behalf of particular plaintiffs swept into the definition of Wayfarer parties. For instance, the Lively defendants threatened sanctions against Jamie Heath on the asserted grounds that 1, Mr. Heath lacks standing to assert an intentional interference claim because the FAC does not allege that he is party to the allegedly interfered with WME contract, and 2, the FAC fails to plead specific defamatory statements about Mr. Heath, but does so only about others included in the term Wayfarer parties. As another example, the Lively defendants complain that Melissa Nathan is grouped under the umbrella of Wayfarer parties in the FAC's extortion claim, even though only Wayfarer, Heath, and Baldoni are proper plaintiffs. The Lively defendants also object that the FAC's false light claim is properly stated only by Baldoni, Heath, Abel, and Sarowitz, and not Melissa Nathan. Simply put, group pleading is the defect at the heart of the Lively defendants' Rule 11 letters. Such purported pleading defects, particularly those already before the court in a motion to dismiss, are not the proper subject of a Rule 11 motion. Such motions are improper if they are substantially identical to the arguments made by defendants in support of their motion to dismiss for failure to state a claim. The Lively defendants' Rule 11 arguments are not merely substantially similar to, but the same as, arguments asserted in their motions to dismiss. Even ignoring the awkward fact that Rule 11 does not apply, group pleading is a common practice. As expressly stated in the responses to the Lively defendants' motions to dismiss, if the court deems this definitional issue to be a pleading defect, it is easily curable by amendment. A curable pleading defect does not rise to the level of frivolous, legally unreasonable, or factually without foundation as required for Rule 11 sanctions. Put another way, if the court grants your client's motion to dismiss in whole or in part, the Wayfarer plaintiffs will amend the FAC as directed by the court, obviating any imagined Rule 11 issue. If the court blesses the pleading and denies your motions to dismiss, any Rule 11 motion by your clients would be rendered frivolous. Indeed, the Supreme Court has recognized the flexibility provided by Rule 11b3, allowing pleadings based on evidence reasonably anticipated after further investigation or discovery. Discovery is in its infancy, and the extensive allegations in the FAC support the Wayfarer plaintiff's good faith belief That reasonable investigation and discovery will uncover additional evidence to support the claims of all Wayfarer plaintiffs. The lively defendant's Rule 11 threat at this early juncture is, to put it mildly, premature, in addition to being improper during the pendency of the motions to dismiss. Hold on, where was this photo? Although given short shrift in the letters, Ms. Lively also invokes the fair reporting and sexual harassment and retaliation privileges, issues that are similarly pending before the court in Ms. Lively's motion to dismiss. Okay. Finally, the letters cynically quote Mr. Friedman, whose statements are not pleadings filed with the court and are thus outside the ambit of Rule 11. Since they have no relevance to Rule 11 sanctions, the only conclusion to be drawn is that the inclusion of the statements in the letters has no purpose but to harass and undermine Mr. Friedman and our firm with the courts, the very conduct sanctions seek to curtail. In sum, the lively defendant's 12 letters claiming the Wayfarer parties have violated Rule 11 are in themselves frivolous and contrived solely to harass and increase the cost of litigation. Such hardball litigation tactics, including threats of Rule 11 sanctions, are improper. Any motion for Rule 11 sanctions will be addressed accordingly. All right. Okay. We're finally at the end of that. So that's almost my cue. Yeah, so I don't know what to make of some of that stuff, to be honest. They might have a point on some of that stuff, but then again, now it sounds like that was not, it was improper to file that in the first place. So now I'm not sure. I'm gonna have to ask someone else, bro. Someone who knows what they're talking about as far as Rule 11 goes. So, but thanks for sitting here while I went through that. I appreciate it. And if anything else comes up today, I'll be back. So thanks everybody. I appreciate you, and I gotta get back to work. So bye. Wait, nope. I'm not going to ignore this because that would be rude. Just Ricardo, thank you for the 2. Hello, lovelies. Hi. Okay. Tom Stansfield, thank you for the 2. Such an awesome streamer. Love from UK. Thank you very much, Tom. I appreciate it. Thanks for watching. And KP, thank you for the 20 Pacer fund. I always appreciate that. That's awesome because the Pacer bill's not cheap, bro. All right. Thanks, guys.